property gets administered by a person appointed by the court to manage that estate. And actually the law defines the various categories of people, as I tried to mention earlier, and each of those categories have their specific shares. And the property is divided under those specific shares. Yes.
You talked about the beneficiaries therein, and you talked about one who is called the heir. Is the heir supposed to inherit property to themselves, as we see most of the cases, or the heir is supposed to be an administrator of the property?
The heir does not necessarily become the administrator. Actually, the law is very specific on the heir, and in all scenarios, the customary heir takes 1%. Whether or not you leave children, in all scenarios, the customary heir takes 1% of the property that you leave without making a will. Yes.
Interesting. We're talking the Succession Act. Please do ask that question, all right? We do have the right authority to speak into this. So if you have the question, get in touch, 0709 602 592. Now let's look at now cases when the will is in place. And am I supposed to give or leave property to anyone I will, in my will, or does the law protect a particular group of people that I must, even when I want or don't want to?
Thank you, Julie. I'll start with the general. And the general is that a person is at liberty to bequeath their property in a way they want. It's a doctrine in law called testamentary freedom. So you're at liberty to give your property to whoever you wish in the will. However, there are categories that are protected, and there is property that is protected. For instance, a person making a will is not at liberty to bequeath the principal residential holding. That is a place where you stay with your wife, your spouse, and children, and other residential holdings. Now, this one tends to look at a scenario where someone has a principal residential holding and maybe children with other spouses where they have residential holdings. So those ones are protected under the law, and they are not bequeathed in a will.
So in other words, just to simplify it for our viewer, is the fact that the home where this person has been residing with their family, wife and children, is by default to that family.
Yes, it doesn't go into the will. You don't bequeath it. You don't give it out in your will. Then in the event that someone gives their property in a will and you fail or omit to make provision for your children who are minors below the age of 18, or those below the age of 25 but are going to school, then the court can alter your will to the extent of making provision for those needs of those little children and even persons with disability. So you need to make provision for that. The other scenario where you can, for instance, bequeath or give your residential holding to another person in a will is where you make alternative provision for them that is equal to the one that you are giving out in a will. Short of that, you can't. Thank you.
Interesting. We are talking about a will, but the fact that in as much as we say that death is inevitable, many Ugandans still fear death.
Sure.
So to that, when exactly is one supposed to write a will?
The time when someone is supposed to write a will is not a question of law, but it's a question of being practical and knowing. Actually, I would advise that any person who has acquired some property, you begin making a will. A person that has the capacity to make a will is that one who is above 18 years old, is of sound mind. You have some bit of property, because death is inevitable. It comes in a time that you never expect. So really, don't leave things to risk. Thank you.
Very, very interesting. You know, for many Ugandans, you have to probably think about it when the days have started, showing you that it's time. But as we're learning, for as long as you're above 18 years, you've acquired some property, you write that will. And how do
and
we...
you're of sound mind.
And you're of sound mind, indeed. Very profound at that. Sound mind, above 18 years. Write your will. When we write these wills, where do we keep them? Do I keep it on the internet, or do I keep it on my email? How do I preserve it? And probably...
A will is a personal document.
Right.
And it is confidential. So we advise that once you write that will, you could keep it with a trusted friend. It could be a bank manager, it could be your lawyer, but also one of the functions of the Office of the Administrator General is that we keep those wills for and on behalf of the public. So come, have your will registered with us, keep it, and notify a few people in the event of death. Come and pick the will, let it be read, and let it be implemented, because it takes effect on the date of death.
Ooh,
yes.
Interesting. So now, looking at the will, what makes it legally valid? I've written it, yes, but what makes it legally valid? And in any case, I know you've mentioned somewhere where the government has the mandate to edit the will in case they realize that you did not do certain things by the law. But what makes it legally valid, and at what point can a family member come out and challenge that will?
Thank you very much for that. For a will to be valid, first of all, you need to look at the capacity of the testator. As I mentioned earlier, the person must be of sound mind, above 18 years, and they should have some bit of property. Now, the will has got to have a date on it. It has got to indicate who you are clearly. And you also indicate the number of the children that you have, and you bequeath the property therein. But as a must, the will must be signed on each of the pages of the will. And it must have two witnesses who must sign on each of the 2 pages. Now, this requirement for signature on each of the 2 pages came up after the amendment of the Succession Act in 2022. Formally, that wouldn't invalidate a will, but right now, if a will is written and you fail to see signatures of witnesses on each of the pages, there could be issues there. So that is critical. And of course, the rationale for that is that we are living in a world where fraud is not something that makes a lot of news.
Yes, indeed.
You could write so many things and sign at the back, then a wise guy comes and changes the content, and then you get bound by a mere signature when the content has changed. So it has become a legal requirement for the will to have the signature of the testator on each of the pages, but also the signatures and addresses of each of the witnesses. There must be 2 or more, not less than 2. Thank you.
So does that mean that based on these witnesses, because in the first place you've just told us that you can keep your will with anyone you trust, especially it could be a lawyer, anyone you really trust. Now these 2 witnesses, they also become privy to the information in your will. Isn't that dangerous in itself?
It's not a requirement for them to know the content. What is critical for them is to testify and attest to the fact that they saw you draft the will.
Okay.
But the issue of disclosure of the content is not mandatory.
That's a good one.
Personally, I've kept so many wills. I have not even bothered to look at the content, but I know their wills, and they take effect upon death.
Right.
It is at that point that you really bring it out and bring the content of the will to the beneficiaries, not to the public. Yes.
Very, very interesting. We're looking at the Succession Act here, and Charles Balala is here in studio with us. He is the Acting Deputy Administrator General to teach us a thing or two. We are learning, unlearning, and relearning this morning as regards to this topic. And someone comes through and says, hi, Julie. Question number 1, what happens if the appointed administrators and beneficiaries disagree and they are all above 18 years? That's the first question. And then the second one, they only sent 2. Is there a timeline for the administrators to act? This is Kelly Wanda.
Thank you. Where the appointed administrators, I think we need to be clear here. Appointed, I want to understand it to mean they have gone through the process of getting letters of administration, and they are more than one. And there is a disagreement amongst themselves on the distribution of that property amongst the beneficiaries. Now the law, I'll not quote the section, appoints the registrar of the court where the letters were obtained as a mediator between the two or more administrators who have a dispute amongst themselves regarding the estate. So once that happens, you go to the registrar of the court, he or she will mediate and have that matter resolved. Now when there is a will wherein executors are appointed and they fail to apply for probate, now the law gives beneficiaries under that will the power to apply for probate. And in applying for probate, they have to come to the office of the Administrator General to get a certificate of no objection, which allows them to apply to court for letters of administration, but with the will annexed. So those ones will implement the contents of the will, and court will give them that power to implement, to execute the will because of the failure of the named executors in applying for the letters of probate. Yes.
All right. 0709-602592. We're looking at the Succession Act, right? Send that question. Send that question. Ask that question. Very pertinent it is, because you have to pick as much as you can from this conversation. Now, when in the case that a husband or wife, of course, has surpassed, what boundaries or rights are the surviving spouse and children operating within?
Okay, thank you very much. Now, for a spouse of a deceased person, there is no automatic right of them dealing with the property of the estate without either letters of administration or letters of probate. For anyone to have rights over property, those rights need to be conferred upon you by either an executor transferring the property to your names or an administrator transferring the property to your names. Now, a spouse has preference over any other in obtaining letters of administration. It's in the law, section 199. A surviving spouse has preference over any other. However, the courts or the Administrator General have the right to dispense with that preference, and there should be reasons. One, the spouse might not be suitable to administer that estate. She could have been implicated in some bit of fraud, she could be sick, so many things, but it is court or the Administrator General that can dispense with the precedence of the spouse over any other person. Yes.
A very interesting question comes through.
Yes.
and I believe it's one that this person is not only asking for themselves, but represents many.
Sure.
Can a son of a daughter be made the heir?
Can a son of a daughter
be made the heir? And I guess I'm not so sure what your context is, but if I could probably read behind what's underlying here is if it's a daughter in this place and not the son in this case, can their son of the daughter in this home or this family inherit?
Okay, if I take her question literally, an heir is a customary heir, and we follow the custom of a place, of a person.
Right.
Now, if your custom allows a female to be an heir of a man, if your custom allows it, it is okay. But if it doesn't, it doesn't. But if it is about inheritance, simply inheritance, and not a customary heir, now the law was amended to give effect to a constitutional petition in 2005 to bring equality of persons before the law on inheritance, whereby there is no discrimination based on gender in terms of inheritance. that one does not exist and it doesn't arise anywhere at all. So if you are a lady, your son can take on property. If you're a gentleman, a daughter has the right to take over property of the deceased. There is nothing that bars them from taking over property of an estate, for as long as it is within the law. The law provides for it.
So what I hear you say is that there's a difference between inheriting property or being instated as
a customary heir, because that goes according to custom. Does the custom allow it?
What if you willed it? What if you willed it and it's against the custom?
Well, it would be, you can will and bequeath property. That is inheritance. Now, for as far as the customary heir is concerned, we look at the custom. Even
when you willed.
But it is of little significance, really. Maybe because a customary heir simply takes 1%. Of what significance is that?
I know, but you'd see.
Unless you want to combine the two to mean the customary heir taking property over and above the 1%, that's a different matter. But if you will them as a customary heir taking, more than 1%, that bequest stands.
But you see, it might not even be about the property, 1% or not. A father or mother might notice that out of all my children, the daughter is well able to lead the rest. Even after I'm gone, they are able to coordinate the rest of the clan. And ideally to them, the leader is in the daughter. So they will that it's the daughter, just for purposes of leading and having everyone together. That is simply
responsibility, and I think nothing bars that in the law. You're giving responsibility.
Right.
The law does not bar that.
Very interesting matters. The law can really play our minds, but it's always a pleasure having those who understand it and have all the authority to speak into it, to come here and teach us all the things that we need to learn and relearn. We're looking at the succession right this morning. On the agenda, with Charles Barara, who is the acting Deputy Attorney General and Administrator General, and he's teaching us a thing or two regarding the Succession Act. Now, the questions are quite a number. I can see an avalanche coming through, but hopefully time allows us so that he is able to chew in on a bit of them one by one so that each one of you is satisfied. Meanwhile, it sounds like the simplest of questions, but perhaps one needs to understand what exactly is the importance of the Office of the Administrator General. What are the functions?
Okay, thank you very much. The Office of the Administrator General has the mandate of ensuring that estates of deceased persons, missing persons, and persons with mental disability are administered in according to the law. Okay? When someone dies, or someone disappears, or someone has a mental disability, they have property.
Right.
Ours is to see that that property is administered in accordance to the law. Now, in doing so, we give what they call certificates of no objection. Section 4 of the Administrator General's Act gives us the mandate, the precedence over any other person to administer estates of deceased persons. Now, we have an entire country where we can't administer all estates. Now, for us to show that we don't intend to administer, we give what we call a certificate of no objection. And in giving that, we vet the family and choose suitable persons according to the law that the family gets consensus on to administer that estate. And it's on the basis of that certificate that someone who is intestate can apply, who dies intestate, the beneficiaries, can apply to court to obtain letters of administration. So we oversee succession. Yes.
As simple as that, yes. But yet also as deep, because your duty is too broad.
Yeah.
And when we see the cases in and out all the time, it paints the picture of the depth of the things that you carry. 0709602592. Let's just engage one more question here. Good morning. Thank you a lot for the show. According to me, if you want to avoid painful succession in families, to write a will when you are of sound mind and trusted people. This is Gidongo Yoweri from Gabugoto, Masira Sub-County in Bulambuli. Indeed, that's the way to go. Hi, Julie. My question is, how possible is it for one of the beneficiaries first to report to the Administrator General and a file is opened, but later on gets himself appointed by non-beneficiaries as the heir and starts to benefit from the deceased's estate. Again, this is Kelly Wanda. Is it a question that you're able to comprehend?
Yes, I understood it. She's asking about one person reporting the death and not disclosing others, and then takes benefit of that estate. First of all, it's an offense. The Act creates offenses where you give wrong information to the Administrator General. For instance, you fail to declare children of the deceased, or spouses, or other benefits, or even property. Failure to declare or declaring wrong information, it's an offense. And if that happened, it is a ground for an application to revoke the letters of administration. So it is not proper. We don't encourage it. Yeah, we don't. And, but it happens in a few scenarios. It happens because...
And to those who commit the crime, what are they liable to?
The offense is created, and one of the penalties is a fine. There is another which is custodial sentence, but also on top of the fine and serving time in prison, there is an obligation to make good the loss that you occasion to the estate.
Looking at
it's a set of offenses created under the Act.
Right,
a set
right.
Of that is one of them.
Interesting, and still sticking with that, but now in line with relatives of the deceased. Do they have a legal right to divide the property in case, say, a will was not left? Or do they still have to go the legal procedures of the Administrator General?
That right only arises where court has appointed them as administrators or executors. Short of that, that is an offense also, which attracts penalties as well. So you don't simply begin distributing just because you're a beneficiary, you begin distributing. No, you're named an executor of a will. You say, I'm the executor. You omit the stage of going to court for the will to be proved, first of all, and getting power to implement the contents of the will. It is an offense. You don't. It is not until you get letters of probate that you can now begin to implement the contents of the will. Where there is no will, and you know your son, you're entitled to so much, it doesn't become yours until the moment an administrator of that estate gives that property to you. And one thing that viewers need to know, even administrators, is that no administrator can transfer property of an estate without the written consent of other beneficiaries. That is critical. So there is a lot of regulation in this, but all intended to safeguard the interest of the estate and beneficiaries. Yes.
When one is having difficulty or issues indeed regarding family estate and inheritance therein, obviously it sounds obvious that they should go to court, right? But of course there's also a DR system, the alternative dispute resolution. What exactly of the two should they consider first?
You know, this is family, and we need to mend relationships within a family. People shouldn't break their relationship because someone died, someone made property, and you're a beneficiary, and because you can't control your simple expectations, you fight. No, we advocate for mediation. Litigation always comes as a last resort, and the Office of the Administrator General is very critical, does a critical role in this. We try to reconcile families, broker reconciliations, and mediate in matters. Court must always be the last resort. Although where things fail, we end into litigation. But we advise that we talk.
In other words, if the worst comes to the worst.
Exactly.
Good morning, UBC. I'm Bernard from Gulu. Painful succession disputes can resolve through alternative dispute resolution. For example, mediation through court-annexed mediation, formal court hearing. Thank you for the program, indeed, and thank you, Bernard, for following all the way from Gulu. We are looking at the Succession Act, and please do ask those questions, all right? 0709 602 592. We've been talking about spouses,
Yes.
wife, husband. In this case of matters succession, who is a spouse?
Oh, thank you. Thank you. A spouse is that person recognized as a wife or husband, married according to the laws of Uganda. Now, we know the laws of Uganda. There is what we call a civil marriage. There is what we call an Islamic marriage, which is potentially polygamous. There are customary marriages, but also there are Mohammedan marriages, Hindu marriages as well. We have an entire set of those, and we know how they relate to each other. If, for instance, you contract a customary marriage, you can't purport to contract a monogamous marriage eventually with another person who is not the person to whom you're married customarily. Those are issues that we normally find misunderstanding on by our clients.
Come again, I think I lost you there.
If you're married
Right.
customarily to one spouse,
Right.
you can't purport eventually to contract a monogamous marriage
Okay.
with a person who is not the one with whom you contracted a customary,
The customary
marriage.
marriage. Okay. Oh.
Unless the customary marriage was resolved.
Right. Right.
Maybe because you only contract a monogamous marriage if you're not married.
Right.
Now, there are scenarios where someone is married under a monogamous arrangement, but eventually they purport to Kwanjula, to do a customary marriage. That one is not valid according to the law. And that person doesn't, the eventual person to whom that person is married does not qualify to be a spouse. But where property is involved and the person eventually dies without making a will, that is the category of property that is protected from being distributed according to being bequeathed in a will. Because you could find I am married, but eventually I purported to marry
Right.
with another person and there are children involved and they have a home. Now that property is ring fenced for those people. You don't bequeath it in a will. Yes.
For the children, ideally.
Yes. No, for the spouse and for that person and the children.
The person with whom you purported
Yes.
the
yes,
legal marriage.
Yes. Yes.
Interesting. Matters the law. 0709 602 592. And in this case, what happens in Uganda? We see many cases of women becoming victims of such cases. Start a relationship with a particular lady, donkey years down the road, 20, 30, God knows how many, you've had children along the way, but never really married. Cohabited and done life together in a way you're married somewhat. But documentally you're not. And then years later, this person moves on to another relationship and probably even weds them. What happens to this spouse that has been in the thick of it all, and probably this property was even, they were part of building this property, 30 years on, and then the wedding, a registered wedding by the law of the land, is with another person. And then, of course, the spouse dies. What happens to one that cohabited?
Thank you. Our laws have not provided for presumption of marriage. The jurisdictions where presumptions of marriage have been made and there is law, enactments to the law, presuming marriage. For instance, if you cohabit for a given period of time, then you're presumed to be married, and therefore you get the rights of a spouse upon death. Our law is different from that. You only become a legal spouse if you are married under the laws of Uganda. So simply cohabiting doesn't qualify you to be a spouse. But if the issues relating to property and you intend to show that you contributed, then it can be resolved at court. If you satisfy court that you contributed, and court can make declarations to that effect, and you take something.
Wow. As is from the things of the law, it looks like in case you're not yet within the trap, you might as well go to that man's house married. you're better off protected from what the law is stating. Good morning, Julie. This is Mugisha Fred. How do you handle the issue where the heir, I think it's the heir of the family passes on, and the sister is living? Can she take on the heir's position and remove the late off the title and retain the ownership of the late's position from their father without the wife and the late's children, who by the time... Your question is quite ambiguous, but if I'm trying to let me try to reread it so that Charles is able to understand it. It says, how do you handle the issue where the heir of the family passes on and the sister living? Can she, in other words, a question, can she take on as the heir, the position of the heir, and of course take off the one who has passed away in line with, and also retain the ownership of the late's position from their father without the wife and the late's children, who by the time of the death of the property were still young? How do you handle this? I hope I've been able to break it down, but yes. That's it.
I think I understand it, and I notice a confusion between an heir, a heir, and an administrator. There is that mixing up of issues where someone tends to think that an heir is an administrator. An heir is not necessarily an administrator of an estate, okay? And an heir is appointed according to custom. An heir doesn't take over property of the deceased. But to give it another, to look at it differently, if she meant an administrator, administration of an estate is granted only by court. And it is granted subject to the consent or agreement of beneficiaries, all beneficiaries. And it is only an administrator who gets registered on the property of a deceased for purposes of distribution to beneficiaries. And by the way, administration is not eternal. It is supposed to be done within a period of 2 years. When the 2 years elapse, you cease to be an administrator. And unless court appoints you or extends the period for administration, you cease. Court can extend for a period of 2 years or such other period as court might deem fit. So it is not a permanent office. It is a responsibility that you owe to the beneficiaries within a limited timeline, and that time is 2 years, or any other time that court might determine.
Right.
Yes.
Right. I hope you indeed, Riza, I hope you've been answered. Now, what are some of those mistakes you've noticed Ugandans make? And when it comes to matters inheritance and succession, what should people do now? What solutions are you giving them now to protect their families?
Thank you very much for that very critical question. The mistake that we do as Ugandans, and people generally, is to fail to do what they call estate management. You know, in your lifetime, you work a lot, you acquire a lot, responsibility, liabilities, so many things. Those are things you need to plan and manage well. There are many ways these can be managed. The commonest is by writing a will. Okay, write a will, detail everything, and determine how you want your property and liabilities to be managed. Give some bit of responsibility in a will. The other, by the way, is a difficult one, but we encourage people. Give out property while you are alive. I don't know whether someone has heard of what they call a gift inter vivos. You have your land, you give it to someone in your lifetime because you know you're not going to live in this world forever. Okay? Give off some of those. The other is by creation of a trust. If you want to create a lasting legacy, while you are even alive, you can create a trust, and a trust has different aspects that I need to bring to the attention of the viewers. It has to have trust property, it could be land, it has to have beneficiaries, those that you want to benefit under it. You name them. Then those that you give the responsibility to manage the trust. So you create a trust in respect of property, and even in your lifetime, you are able to see how the trust is running, how it operates. You're even able to make amendments if it doesn't work well. So when we fail to do estate planning and estate management, we create chaos, we create division, we create trouble in families. So I would implore our viewers and Ugandans at large to try to take a moment and think about what you leave. Plan your estate well, give responsibility, and diminish the instance of disputes in the event of death, because death is a sure thing for everybody.
Right.
Yes.
Take a moment and think about what you are leaving behind. That's rather profound, and it's a moment of selah for you. Is customary marriage recognized? I would say yes, but allow me also let the authority in this speak into it. Is customary marriage recognized by Uganda?
Yes, it is, and I would encourage as many of you to contract customary marriages as opposed to cohabiting.
Right?
Because cohabiting doesn't create rights upon death. But the moment you are customarily married, you are in the same standing as a person that went to church or went before the register of marriages. So it is recognized.
Thank you for the show. Someone, this one says, the dad had 2 wedded spouses on acquiring the property. Then later, the dad got another unwedded spouse. Both the dad and one of the wedded are deceased, and the land has no land title. But there is the heir. How should they distribute the land? This is Kakaire Fred in Nansana.
Okay, thank you. I want to understand that question to mean that the 2 wedded spouses were wedded one at a time.
One at a time,
because there is no way you can be wedded before the dissolution of a marriage.
Right.
There is no way you can contract another valid wedded spousal marriage.
Right.
So I want to imagine that the 2 wedded were one at a time. Or you get one, maybe she dies, or you divorce, then wed another. Of course, the effect of divorce is that you cease to have an interest in an estate of the person from whom you divorced, because that one is determined at the point of divorce, dissolution of the marriage. Now, I also want to imagine that he is referring to the subsequent customary marriage after the death of both the wedded spouses. Because if those 2 were still, if one of them was still alive, there is no way you can again purport to contract a customary marriage. That one becomes invalid, and actually that person with whom you are wedded does not have an interest in your estate, in the estate of your dad. So those are critical issues that we need to look at.
And from what I see, it looks like the dad had 2 wedded spouses. One passed away, but of course, along the journey of life, he married another customarily.
Well, the other one was living?
Possibly. So it looks like the first 2 that were wedded, one passed away and remained, one was left, and then the dad had another customary marriage.
That was invalid. It was an invalid marriage. That is just a girlfriend.
Ouch. The truth stings sometimes. UBC inspiring Uganda, indeed. We thank you for getting in touch and proving the fact that you are inspired. I am with Charles Balala. He is the Acting Administrator General, and he's speaking to us about the Succession Act. I believe there's a lot of things you've learned. I think for me, a lot has stood out, but one of them, I should say, is just the will itself, the paper, or the document. When you write it, what does it entail? The 2 witnesses, something no one, I don't think I'd ever thought about the 2 witnesses up until today. So I do appreciate you for teaching us this morning on the things that are very important and pertinent. What are your final remarks?
I would encourage our people, the viewers, to think critically about estate management. Make use of the Office of the Administrator General. It is located on Katalima Road, Jealous Towers. It is open all the time. working days, working hours. Come seek our services. They're free of charge, and we'll be very pleased to serve you. Yes.
Thank you very much for coming through.
Welcome.
It's been a pleasure. And we do appreciate you for watching the show. And following on, Chirabo will also be coming through with Good Morning Uganda, the extra. But for now, we close it here. And of course, tomorrow is a Wednesday, another day to be inspired as a Ugandan. But from me, for now, for God and my country, good morning.
Live from UBC Studios in Kampala, this is Good Morning Uganda.
All of Africa, welcome everyone.